Thank you, Mr Speaker. It's my pleasure to speak to the Trans-Tasman Proceedings Bill. I was a member of the Justice and Electoral Select Committee which considered this bill, and I'd have to say that with bills like this you often see select committees sometimes at their best. It is simply a matter of making sure that we've got all of the nuts and bolts worked out, because of course this is a piece of legislation that has traversed both a Labour government and now a national government. And I would like to just point out that a piece of work like this simply doesn't come together in the past 12 or even 24 months. In fact, this bill results from a work program that really, if we were going back to its foundations, would be under Helen Clark, and probably I think it was 2003 in conjunction with John Howard, how things can change. And eventually through an agreement signed by Leanne Dalziel in 2008, which I think was an appropriate commentary really on where we currently are with our CER with Australia, and just how it is now becoming incorporated into so many pieces of our legislation and our legal frameworks as New Zealand's ties with Australia become closer and our borders between the two weaker and weaker, I guess. The Minister has already pointed out that the primary aim of this particular bill, which is to simplify the resolution of legal disputes which do traverse across Trans-Tasman boundaries, is essentially to try and reduce the cost and complexity of Trans-Tasman litigation. And I think it's something that very few people would hold any objection to. But I do also want to point out that in the wider context of New Zealand's closer legal relationship with Australia and both countries' attempts to streamline and create greater efficiencies and acknowledgement of the globalisation that we are all now subject to, that we do still maintain, obviously, our own sovereignty, our own right to make decisions that reflect the New Zealand context when it comes to our legal obligations in consulting with our Australian counterparts under various treaties. And I think that was probably demonstrated most recently in the decision that the Minister of Food Safety made around folate. Because, of course, in the Food Safety Act, it sets out that the Minister is obliged to consult with her Australian counterparts to ensure that we comply with our agreements in that area, because again, that's another area where we've tried to streamline. And the Minister demonstrated that New Zealand can make its own decisions. Now, Labour would argue that it was absolutely the wrong decision that she made, and an abhorrent one at that, to decide not to introduce folate into bread, and we will be suffering the consequences of that. But it probably does again demonstrate the point that New Zealand does still maintain a level of sovereignty over those mutual agreements and treaties. I don't think it was the best way to prove that point, and I think we will continue to suffer for that. But it was just an example I thought it would be timely to raise. I just want to go over some of the points in the bill, which I think demonstrate, though, how we've maintained the balance between ensuring the key elements of our justice system are maintained in the way that this piece of legislation will work. But it is a significant, nonetheless, piece of work. David Goddard QC, who was originally a member of the Trans-Tasman Working Group, did say that these are the furthest reaching proposals between two sovereign states with separate legal systems. So let's be under no illusion, they are significant, but a lot of work has gone into them. I think the working group was established back in, at least reported in 2006. And amongst its recommendations, it did delve into how New Zealand and Australia would apply differing rules around the use of video technology. And of course, since those recommendations have been made. We, of course, introduced earlier this year our own legislation on the use of audio-visual link technology in courts. And I think eventually got the balance right. Members of this House will recall that there was a considerable stoush in this House over whether or not the extension of the use of AVL technology had gone too far, but I'm very pleased a compromise there was reached, and I think we got the right outcome. But with AVL technology in this particular bill, the Select Committee made it clear. I accept, Minister, that stoush may be too strong a word, and I do acknowledge the fact that he made a considerable concession from his perspective, and I do appreciate that. I think the words we use in this House is robust debate. But the Select Committee did make it clear that the Courts Remote Participation Act will not apply to remote appearances made under this bill, and in fact that the Trans-Tasman evidence regime will operate in parallel and will not override or be subject to the Mutual Assistance in Criminal Matters Act. So I think it was important, given the fact that the Select Committee had dealt with both pieces of legislation, that they ensured there was clarity around that. But what are the main provisions of the bill? Well, essentially I think they could be drilled down into 7 parts, and I just wanted to traverse some of those briefly. The first of which is when civil proceedings are commenced in New Zealand. The bill provides that an initiating document for the proceeding may be served in Australia as well. And there are 3 exceptions to this, but I think each of those are reasonable. And I think some other members of the House have already talked about the kinds of circumstances that might arise from civil litigation, for instance, over the sale of a house, etc., where one of the seller may have moved overseas. Well, this now means that if those civil proceedings related to New Zealand and began there, that initiating documents then can still be served to an individual based in Australia, which I think we have to acknowledge can be commonplace now, given the state of movement between our 2 countries. Second key point in the legislation, a defendant in a civil proceeding can apply to have proceedings heard in Australian court where certain criteria are met. And also, that was actually one of the changes that the Select Committee made. We wanted to make sure that the bill was consistent over where proceedings were heard, and we wanted to make sure that a person served in Australia for New Zealand proceedings can apply for a stay of proceedings on the grounds that the matter should be dealt with by an Australian court. So that was about ensuring consistency with the other subparts in the bill. The third relates directly to a party to civil proceedings commenced in Australian court may apply for interim relief in a New Zealand court. The fourth was around the remote appearances and remote evidence, which is covered by the Evidence Act, and I've already clarified the hierarchy of legislation in that regard. And then the fifth was the recognition and enforcement in New Zealand of specified Australian judgments. So this is actually quite an important piece of the bill, I think. It provides for the enforcement of Australian judgments in New Zealand and goes beyond just final monetary judgments. Now, there was some discussion in the Select Committee about how this related to guardianship, and we did have some very important technical submissions around this, and I thank those submitters who made those contributions to this bill. And I think those probably cover the most significant parts of the bill. And I think the Select Committee's contribution was made primarily, it was obvious that when the Select Committee was hearing evidence on this bill and considering it in detail, that it was at the same time that officials were working alongside Australian counterparts to make sure that we had married up both pieces of legislation accurately. And so a lot of the changes that were made at the Select Committee, I think, really probably bear that out, that that's the point in the process that we were at. But in conclusion, though, Mr Speaker, I think, again, this demonstrates an important piece of work that shows that we do have to acknowledge the greater transience between Australia and New Zealand, the fact that family relationships, legal relationships cut across the borders of Australia and New Zealand on more and more, and our legal systems need to demonstrate that. But at the same